Hi, this is the Business Guy. So what is a land trust and how do they work? And most importantly, what can it do for you? My team and I have set up over 2,000 land trusts, and we're going to talk about who should be the trustee of a land trust pros and cons, how land trusts protect your privacy, and how to use an LLC with a land trust. Now, a land trust is a private agreement to hold title to real estate. And I'll go ahead and show you an example of what a land trust looks like in a little bit. With a land trust, one party, the trustee, agrees to hold the title of the property for the benefit of other parties, the beneficiaries. And the one who establishes the trust is called the settlor. So let me show you what a land trust looks like, and then we'll do a little further breakdown to clarify the roles for each party in the trust. So here's an example of a land trust. It's about 29 pages, including the deed and the instructions. We also provide the deeds, and this is the document that actually transfers the property into the land trust. We provide a grant deed, warranty deed, and quitclaim deed. That way you can use whichever one is most common in your county. We also include a document called an assignment of beneficial interest, and you can use that document to assign your beneficial interest in the trust over to an LLC so you have better liability protection. We'll talk more about that later. Okay, let's break down the roles for the different parties associated with the trust to try to understand that a little better. We'll go ahead and start with the settlor, but first it would help me out a lot if you'd settle your thumb or your mouse on that like button below so YouTube promotes this video. I'd really appreciate it. And if you haven't already, you can go ahead and click that subscribe button below so that when more videos come out like this, you'll be up to date right away. Hey, it's free and I'd really like to see you again. Okay, so who's the settlor? The settlor is the one who calls us and has us create the trust, and is also usually the one who held the title to the property before transfer into the trust. Now, the settlor is often the beneficiary of the trust as well. So naturally, people who call us to establish land trusts are usually the people who own the real estate. Beneficiary. The beneficiary typically receives the benefits of the property that the land trust owns. So the trust beneficiary usually enjoys the proceeds of the rental or sale of the property that the trust owns. Alternatively, the beneficiary will often transfer beneficial interest in the trust to a limited liability company, LLC, and the LLC can give legal protection in the event of liability on the property. Plus, the LLC can also offer asset protection to hinder the seizure of the property should somebody sue the LLC member. So if somebody sues one of the people associated with the property, the LLC can protect that property from being taken away. The addition of the LLC is primarily for income property rather than one's primary residence. Now, this is primarily because the personal residence is in a separate tax bucket, a separate tax category. So when you live in the house, you'll usually want to personally remain as the trust beneficiary, and that way you can write off your mortgage interest on your personal taxes. Plus, when you sell your personal residence, you can avoid paying taxes on a significant portion of the profit. So that's why for your personal residence, you want to be the trust beneficiary rather than transferring your beneficial interest to an LLC. For your income property or a second home, however, we like the LLC to be the beneficiary for liability protection. Trustee. Now, the trustee holds the title to the property. If so drafted, the trustee must follow the instructions of the beneficiary. As such, the beneficiary typically has the right to both direct the trustee and receive income from the trust. And as a further background, I'm the CEO of Lawyers Limited and Asset Protection Planners. We're the largest asset protection company in the country. We have attorneys on staff. So if you want to set up a land trust, feel free to give us a call or fill out our free consultation form on our website at assetprotectionplanners.com. So who should be the trustee of a land trust? Who should be the trustee really depends on the purpose of the land trust, but most people set them up for privacy of ownership. So we'll address the question as if the purpose of the trust is anonymity. Now, when this is the case, the trustee should not be the settlor or somebody with the settlor's last name. So the trustee could be a trusted friend or relative, but better yet, we often set up an LLC to serve as the trustee. This way, when the settlor, or you, is the manager and or member of the LLC, you can maintain the control. Plus, what we've seen is that when somebody asks a friend or family member to serve as the trustee, uneducated trustees often become quite uncomfortable serving in the trustee capacity. Many trustees, rightly or wrongly, and mostly wrongly, are concerned about personal liability. So that's why we set up many LLCs for our clients to serve as trustee. And this trustee will be a different LLC than the trustee that they can assign the beneficial interest to. It needs to be a separate LLC. Okay, let's talk about having a Wyoming LLC as the trustee. Most often, we set up the trustee LLC in the state of Wyoming. The reason is that Wyoming LLCs offer enhanced legal protection. One member can enjoy charging order protection, for example. Plus, we usually include the added services of the Wyoming virtual office, so the LLC has an address and phone number in Wyoming for extra anonymity. That is, you don't have to use your home address. Plus, we add the nominee manager services. Nominee means in name only, so with this service, you can own and control the company, yet our personnel shows up in the public records as manager. We also have a nominee service agreement that says what the nominee can and cannot do. Basically, the nominee cannot do much without your written instructions. Therefore, by placing an LLC in the position of trustee, it can give you the benefit of control, plus it gives the added benefit of privacy. Okay, summing up the previous section, who does what to who? Here's a summary of how the three parties in the land trust relate to one another. The trust agreement at the creation of the trust governs the relationship between the trustee and the beneficiaries who receive the benefit of the property. So the trustee often has no more power than the settlor gives him in the trust agreement. And this is because we intentionally draft the trust for the benefit of the settlor and the beneficiaries. Plus, the trustee typically has no other function than to do as the trust deed instructs. As mentioned, the settlor and beneficiary are most often the same person or the same people. And as we discussed, the trust settlor can elect to have his or her own LLC serve as the trustee. And again, this gives the settlor substantial control over the trust. Therefore, the settlor does not need to involve a third party that may fear risk or not act as quickly as the settlor desires. Revocability. Land trusts are most often revocable. Therefore, the settlor may change, modify, or terminate them when he or she is still alive. For example, the beneficiaries may remove an uncooperative trustee. Since the trustee holds title as a fiduciary, they incur no personal liability for merely being on the title, nor can the trustee lose the property to his or her own personal creditors. Okay, so let's talk about land trust pros and cons. First of all, land trust benefits. Now, there are many land trust benefits, and here are some of the biggest advantages. Privacy of ownership. Under a land trust arrangement, your identity as trust settlor and beneficiary remains private. The trust itself doesn't get recorded in the public records. Only the deed showing that the land trust/trustee owns the property is what shows up publicly. So the legal owner of the real estate, the beneficiaries, is not disclosed except in cases of subpoena or court order. Ease of transferability. The land trust beneficiary or owner may be changed without recording a change in the public records. So you can sell the rights to the property without changing the property title. And you do this by simply changing the trust beneficiaries or assigning your beneficial in the trust to somebody else. Privacy of transfer. Assigning beneficial interest in the trust is typically not public. Aids in lawsuit prevention. A contingent fee attorney may not accept a case if he or she cannot find your assets. Avoids probate. A land trust arrangement allows you to designate succession of ownership, and you can do this as you wish, thereby avoiding probate and costly, time-consuming proceedings relating to the property. Facilitates multiple ownership. Where there are many owners, a land trust can have multiple beneficiaries. You retain the tax advantages. Now, you're still eligible for the homeowners and senior citizens real estate tax exemptions when you hold your property in a land trust. Can use it in any U.S. state. Now, not all states have land trust laws, but not all states have laws saying whether or not you can wear red shoes either. Not everything you can and cannot do is codified into law. And we have clients who've used these trusts in all 50 states. Now, Tennessee may be one exception, though our clients have used them there. Helps avoid the due on sale clause. Now, the Garn-St. Germain Act allows you to transfer 1 to 4 dwelling units without invoking the due on sale clause. Keeps the sales price secret. When you assign beneficial interest privately, the sales price is not made public. Helps prevent property liens. That is, a judgment against a person does not automatically attach to the property. Attaching a personal lien to the property requires additional legal proceedings. Okay, now land trust disadvantages. Whereas land trusts have many benefits, there are also some small disadvantages as follows. Financing. Lenders may require you to place the property in your personal name prior to obtaining financing. Then you can transfer the property back into the trust after obtaining the loan. Does not protect from lawsuits. You may need to include an LLC, for example, as the beneficiary for lawsuit protection. Okay, now how land trusts protect privacy? The land trust is comprised of two legal documents. There is a trust agreement among the settlor, trustee, and beneficiaries. This document establishes the right, powers, duties, and obligations of the parties. And secondly, a deed from the settlor to the trustee. First, you execute the trust agreement by signing it and having your signature notarized. Then you sign and have your signature notarized on the deed, and then you record the deed. You keep the trust itself in a file cabinet at home or in a safe deposit box. And once completed, the recorder's office will no longer reveal to the world that you are the owner of the property. In addition, the trust agreement remains private in your file cabinet at home. Thus, nobody needs to know that you retain the interest in the property. That is, the public records will not reveal this information. Litigators generally have no interest in suing people who have no assets. What is one of the easiest ways to find out if you have deep pockets? You do a public record search for real estate holdings. For the successful real estate investor, this search could paint a big fat bullseye on their backs. Whereas a land trust is not a true asset protection trust, it is a powerful privacy tool and helps to ensure that a litigator's search for deep pockets comes up empty. Okay, so let's talk about LLC plus land trust for asset protection. First, as we said, a land trust is a privacy device, not a corporate entity. Accordingly, land trusts do not enjoy the liability protections that corporations or limited liability companies may enjoy. So if somebody slips and falls on the property, the beneficiary can be held liable. That is why we establish a corporation, LLC, or limited partnership to serve as the beneficiary. Second, one can usually transfer the property into a land trust free from taxation. The Internal Revenue Code addresses this. In fact, the federal government will treat the property as if it was owned outright by the beneficiary. See IRC section 671-678. In addition, in most states, the transfer of a property to a revocable trust, such as a land trust, does not require transfer or recording taxes. Finally, here's what many investors find. Most attorneys and accountants have no idea what a land trust is or how it works. While this can certainly be frustrating, there is an upside. Think about it. This means that many of the litigators in your community will be unfamiliar with land trusts, and a significant number will stop their search for deep pockets at the end of the public records trail, which is the county recorder's office. So in conclusion, a land trust is an ideal tool for privacy of ownership. Keep in mind the land trust by itself does not provide true asset protection, and there are tools that can provide real estate asset protection, such as the LLC as the trust beneficiary. So you can use a land trust for lawsuit prevention. That is, so a contingent fee attorney does not readily see that you have deep pockets. And that is because, as we have clarified, the land trust conceals your ownership. For liquid assets, on the other hand, offshore trusts provide the most powerful asset protection, and you can watch our videos on that next for more information. Hope you enjoyed this video on land trust. Please click like, subscribe, and share this video with others. See you next time. This is The Business Guy.